Hi, and welcome to episode 2 from the Elder Law 101 series that I have revised for 2025. If you don't know, haven't done this series before, my name is Arthur Bergeron. I'm an elder law attorney. I'm at Myrick, which is a large multi-specialty law firm in Worcester, Westboro, and Boston, actually. We have about 80 lawyers. And I do nothing but elder law. And this series was really designed to try to deal with all of the issues that you may have dealt with in the past, but also the issues that you are going through now if you, like I, am older. I am 75 this year, and I always tell people I like what I do because most of my clients think I'm young because I do nothing but elder law. So we're going to talk about issues, and we're going to talk about my friends Frank and Mary and their kids Peter, Paul, and Mary Jr. You're going to meet them during this, this presentation. And just to give you a sense of how this series works, I already talked about Frank and Mary in the first episode when they were under 60, because they have a set of issues, whether they were 30, 40, 50, or 60, their issues basically as an estate planning matter stay the same. But then they get to the 60s and things change, perhaps because they're not working, and so they're trying to figure out how does Social Security work, how does Medicare work. There are a bunch of issues. And we're going to talk about that today. We'll also do an episode dealing with your 70s when their issues change again, because they're increasingly thinking about, can I continue to stay in this house? Do I have to change it? Do I need to move? How's that going to work? And in the long run, do I need to worry about what happens if I get frail? Then in episode 4, we talk about income tax basics for seniors. There are some issues that uniquely face seniors or folks who are older, having to do with the interplay between the regular income tax, the capital gains tax, and the estate tax. We're going to talk about life in your 90s, life in your 80s, when folks are frail and they're trying to figure out how to deal with that. I do a separate episode on why you can always qualify for Mass Health, the Massachusetts name for the Medicaid program, which always amazes people. I do an episode on the last year of your life, which you may be going through right now and not know it, but there are a lot of issues surrounding that last year that I ask people that they should really think about. Then I talk about things that you left behind and how to deal with them after you're gone, whether through the probate process, through trusts, or otherwise. I do a separate episode just about trusts, revocable versus irrevocable, testamentary versus living. All of these issues, when people come in to me and say, don't I need a trust? And it's to deal with all of that. I do an episode just on all about the kids and the grandkids, that is after you're gone. How do you want things to work regarding distribution of your assets to the children or grandchildren or whoever? There's an episode on dealing with your Medicare package, which is a big deal once you're in your 60s and beyond. And then finally, 'Tis the Season. This series was designed originally as a 12-part series that I presented a lot at senior centers, and the last episode was done in December, so it was 'Tis the Season, and we talked about both tax planning and giving, which are the two things that you want to be thinking about in December. So if you haven't seen them before, I'm talking about my friends Frank and Mary and their kids Peter, Paul, and Mary Jr., and I always tell people, if you're old enough to get the joke, you're old enough to be my client. And their goals in life are very simple. They want to live in their house until they die. They want to be buried in the backyard. They want to leave everything to the kids. They want to avoid probate if they can, just because they know it costs money. And they want to avoid taxes. Does any of this sound familiar? Right? So I also talk about Mary's sister Peg, who is single and has one child, sometimes called Peg Jr. or sometimes called Peggy. And I'm going to talk about her issues. They are really, in many ways, the same issues that Mary would face if Frank were dead, right? And she was a single person. But we're going to talk about her as a separate person, because many people will come up to me after presentations and say, this isn't relevant to me, I'm single. So we're going to talk about you if you're single. So first, though, Frank and Mary. We're assuming, in this case, that Frank and Mary have assets, including a house, Frank's IRA, joint savings, and life insurance. We're going to assume they live in two different places, though, the two places where I spent a lot of time. In the Metro West area, where their house is worth $400,000. The other assets are the same. And on the islands, Martha's Vineyard and Nantucket. Many people know that for me, Thursday is always Island Day. I always go to one of those islands. And so for the and I don't deal with the rich people who fly in and fly out of those islands. I deal with the locals who are always there. For them, the Frank and Marys on the islands have the same basic assets, except their house is worth a ton of money because it happens to be on the island. So on the islands, we're saying that their house is worth $1 million, and therefore the total value of their assets in Metro West is $2.1 million, including that big life insurance policy that they still have. And they may want to consider getting rid of it at this point because their kids have now grown up. But, that's a decision that maybe they want to make in their 60s. If they're on the islands, their total assets are worth $2.7 million. In either case, there's an estate tax question. I'm going to spend some time talking about that. So, before I go into their details, let me talk about the federal gift and estate tax system. Because there is, for estate tax avoidance purposes, you need to understand there is no Massachusetts gift tax. And therefore, under current law, you can give away all of your assets the day before you die and therefore eliminate your estate tax. Well, somebody at the federal level thought of that. Actually, it's my understanding that both of these estate tax systems were created in the 1920s, right? And so at that time, the federal folks said to themselves, well, we don't want that to happen. We don't want people to just give away all their assets the day before they die and avoid the estate tax. So at the federal level, there is a combined gift and estate tax system. And here's how it works. The estate tax, there's an amount of, if you die leaving an amount above a particular, an estate above a particular amount, unless you're leaving it to your spouse, in which case everything you leave to your spouse is always subtracted from the taxable estate, there's an estate tax. That amount this year is, in 2025, is $13.99 million. If you make gifts during your lifetime, there is a gift tax, unless you qualify for one of the two exclusions. The one that everyone has heard about, and the one that I guarantee you've heard about, and in the back of your mind you're like, oh no, there's a certain amount that I can't, once I give away more than that amount, something bad happens, right? Well, that amount used to be $10,000 a year, $10,000 per person per year, but there is an inflation provision in the federal law. So this year, in 2025, that amount is $19,000. And if you give away less than $19,000 to a person, then there's an exclusion in terms of the gift tax. But there's also another exclusion, the one that you've never heard of. And that is that in addition to those little exclusions, you have a lifetime gifting exclusion equal to the estate tax exclusion, $13.99 million. So unless you're intending to give away more than $13.99 million during your lifetimes, there is no gift tax. Well, but people will say, but wait, don't I have to do what, right? Well, I think the reason why I think that everyone thinks that there's this big deal around the gift tax is because of what I would always call the conspiracy of the tax preparers and the accountants. No offense to tax preparers and accountants, but I take a lot of jokes from them. I hear all the lawyers' jokes. So if you have a tax preparer or an accountant and it's the end of the year and you're starting to get your information ready for the following year, you're probably going to get a questionnaire from them. And they're going to say in the questionnaire, among other things, did you give a gift in this year that was more than $19,000 to anybody? And if you answer yes, they're going to say, oh, well, in that case, you have to file a gift tax return. Which is true under the federal law. It does say that you're supposed to file a gift tax return if you gave away more than that amount. And the reason, I presume, is because there's like a secret office of the IRS in the basement. There's this one guy, and all of these returns get sent to him, and he's got this big like abacus, and so that he can take the amount that you gave to your son Charlie that was more than $19,000. Say you gave him $20,000, he can take the extra $1,000 and subtract it from the $13.99 million that you can leave during your lifetime. So now that amount has gone down by $1,000. Now, and so I haven't met that person who's in that basement, but The point, though, is, and if your accountant or your tax preparer says you have to file that gift tax return, ask them, so what if I don't? Because the answer is that nothing bad happens if you don't, because the only penalty for failure to file that gift tax return is the interest that you would have owed on the tax that you would have owed, but you don't owe any tax unless you're giving away more than $13.99 million. So this whole gift tax thing is just like a myth. So that's the federal gift and estate tax system. So what you're left with then is the Massachusetts estate tax and how to avoid it. Because there really is a Massachusetts estate tax that Frank and Mary need to be concerned about. Now, as I mentioned, the Massachusetts estate tax was created back in the, I think this was the 1920s, and the point of the estate tax was to impose a tax on the estates of people who died leaving a lot of assets. And a lot of assets at that time was considered to be $40,000. And so at that time they created this chart, and they said, well, according to this chart, if you had assets of less than $40,000, there's no estate tax. If your assets were between $40,000 and $90,000, an estate tax of 0.8%. Between $90,000 and $140,000, it goes up by another 0.8. These all go up by 0.8. So then it goes up to 1.6, and then it just gradually goes up. And the bottom line, and I'm focusing on this because the two numbers that you already heard were that in Metro West, Frank and Mary had total assets of $2.1 million. If you had assets of $2.1 million and you left it all to your spouse, there's no estate tax. But if the spouse dies the next day with those assets, there's an estate tax of $11,520. The taxable estate on an estate of $2.7 million is $61,280. Now remember, if the total taxable estate were $2 million or less, the tax would have been zero. So basically these numbers are the extra money with the tax imposed, which starts off at 7.2% and somewhere in there turns into 8%. So there is no tax on a taxable estate that is below $2 million. The estate tax avoidance plan for Frank and Mary, there are a couple of things they can do. The most common estate plan would be that especially if Frank and Mary were trying to also avoid probate, is that each of them would create a trust. And that trust would say that whoever's assets is their trust, they'd probably both be the trustees of each trust. So Frank and Mary would be the trustees of Frank's trust. Frank and Mary would be the trustees of Mary's trust. But they would both say, if I die, the other spouse stays on as the trust. So if Frank dies, then Mary stays on as the sole trustee of that trust. And the trust would say that up to $2 million of the assets that are left by the first spouse, instead of going directly to the surviving spouse and therefore not being countable at all for estate tax purposes, gets held in trust for the benefit of the surviving spouse. Now the surviving spouse can actually be the trustee of that trust. So if Frank dies and he's got assets that are up to $2 million that are in this trust for Mary's benefit, and he dies, Mary becomes the new trustee of the trust. Mary can have total control of these assets and can distribute them to herself at any time using the HEMS standard, health, education, maintenance, and support. But anything that provides for those things for herself, she can distribute money to herself. If things are structured that way, then when Frank dies, any assets that are going into that trust will be subject to the estate tax, except that because there's less than $2 million, there will be no tax. It's subject to the estate tax system, but remember, there's an estate tax threshold. Below $2 million, there's no tax. But the interesting thing about that is that what we would tell Mary in that case is regarding those assets that are in that trust. You're now the trustee, Mary. You can pull this money out any time, but don't do it unless you have to. because any money that is still in that trust when you die is not going to be counted as part of your estate. And if by doing that, you've reduced Mary's estate to less than $2 million, then the end result is there is no estate tax, because Mary's estate is less than $2 million. There's no estate tax below the threshold of $2 million. So the estate tax minimization and probate avoidance plan for Peg, though, right, is a little different. Peg can't play the game that I just described, where some money can be parked on for her benefit and not get counted when she dies. Instead, what she could do is give away enough money before she dies in order to get below that magic number of $2 million. So what I would tell Peg and her daughter Peg Jr., especially if Peg Jr. were older and were her power of attorney agent, or whoever was her power of attorney agent, is I'd say, look, if Peg's getting sick, if Peg had a stroke and it looks like she's about to die, if she just had a car accident, or I would tell Peg, if you got cancer, I deal with a lot of clients who die. I deal with I have between 2 and 3 clients of mine die every week. I have 2,500 clients, but they're all old, so people are now dying. And so I find myself talking to clients about like the better ways to die. And I have to say that in many ways, cancer is not a bad way to die, because as long as you don't have one of the ones where it causes you a lot of pain, because you're very cognizant of what you're doing until pretty close to your death. So if it were Peg and she were dying, she would have the ability at any time prior to her death to just give away enough money to get below that $2 million. And there's no so-called look-back period regarding any of this, so she can literally give it away the day before she dies. And there's no gift tax, as we talked about. Now, there is another mechanism that she could use because she has life insurance. And assuming that the life insurance is a so-called term policy, has no surrender value, she could give away that policy to something called an irrevocable life insurance trust, to a third party as the trustee of the irrevocable life insurance trust. And a year after she had given that policy away, if she died a year and a day later, the money in that islet, even though it was going to Peg, right, and was being transferred as a result of her death, right, would not be considered as part of her taxable estate. If you want to learn more about that, I'm doing a series of shows. I used to call these shows Bergeron Briefs. They're short 5 to 15-minute presentations on a very specific elder law topic. All of the new ones that I'm doing starting in 2025 are called Myrick's Pearls of Wisdom. You can find these on Frank and Mary's YouTube channel, and we'll talk about that later, or by going to the Myrick YouTube channel. So finally, there were 2 things that Mary would want to, that Peg would want to avoid if she were trying to get herself below that $2 million. She would want to avoid giving away tax-deferred money, like her 401k, because in order for her to give it away, she would have to first cash it out and pay all the income tax on it. That wouldn't be smart. Her income tax would be way more than the estate tax. She also wouldn't want to give away her house if she paid very little for it, because if she gives away her house, the so-called tax basis in that house, what she paid for it, would still be the basis for calculating the capital gain that Peg Jr. would have to pay on the house, whether Peg Jr. sold the house before or after Peg died. If, on the other hand, she keeps the house until she has died, the moment of her death, the so-called tax basis of that house will jump to the date of death value so that Peg Jr. won't pay any capital gains tax. The capital gains tax, Peg Jr. will find, is going to be way more. The savings on the capital gains tax is way more than the cost in terms of paying the estate tax. So that would be basically Peg's plan. Now, go back to Frank and Mary, a different issue. Dealing with Frank and Mary's tax-deferred funds. As you see, once again, they're in their 60s, and Frank's got an IRA worth $400,000. So how should he be dealing with that? Because he's 60, he can now pull out any amount of that IRA without having to pay a penalty. He is not going to be required to pull out any money until he's quite a bit older, until he's like 73. So in his 60s, he doesn't have to take out any of this money. And he knows that if he takes out any of it, with whatever he takes out, he's going to have to pay an income tax on. So, as indicated, if he withdrew money before age 60, he'd be paying a 10% penalty. If he had a 401k, that is an employer-based deferred income program, he would not be required to take out any withdrawals while he was working. I am 75, for example. We have a 401k at Myrick. I'm not required to take out any payments on that 401k because I'm still working. If the money has become IRA money, he's required to start taking out money when he's 73 and a half, so he's not thinking about that, right? If he dies, then upon his death, Mary can convert any of the money that is in his 401k or his IRA into her own IRA, right? And so he doesn't have to kind of worry about that. If, by the way, as part of his estate plan, he transfers money in trust to his spouse, as opposed to giving it to her directly, then she does not have the ability to do this. So when Frank is trying to figure out how to make sure that when he dies, some of his assets don't end up getting included in Mary's estate when she dies, one of the assets that he probably would not want to include in that trust for Mary's benefit is his IRA funds. So for all of this, he'd want to be talking to his tax advisor. He'd probably also wanting to be talking to his lawyer. The question for Frank is, should he be taking any early withdrawals? And if so, what should he be doing with them? The major reason why Frank may want to consider early withdrawals, this is going to become more significant to Frank when he's a little bit older, is if he is worried that at some point he may need to qualify for MassHealth, the Massachusetts name for the Medicaid program. If that were the case, he could qualify for MassHealth, and I'm going to talk about this in a later seminar. He could qualify for MassHealth at the last minute by taking all of his assets and moving them to Mary. Mary could then take some other steps regarding those assets. The issue, though, is that if he needs to pull all of that money out at the last minute, that money is all going to be added to Frank and Mary's taxable income for that year, and he may end up paying a very high federal tax rate on that money. He may decide, therefore, that for MassHealth related purposes, for MassHealth asset protection related purposes, he wants to start drawing that money down over a prolonged period so that he's not paying a high federal income tax rate on that money. What does he do with the money? Well, he can simply pull it out and start investing it. He could also convert it into a Roth IRA. Why a Roth? Because the Roth, once the money is in, he's going to pay income tax in order to do that conversion. But once the money is in the Roth, any further growth in that money is going to be tax-free. So he would have the ability at the last minute to shift money to Mary without taking an income tax hit. When do Frank and Mary want to start taking their Social Security payments, right? So Frank could start taking payments. Oops, that's a mistake. Frank could start taking payments as early as 62, right? At Frank's age, if Frank were to not qualify, try to qualify right away, but to wait for a few more years, he wouldn't have to start taking payments until he was 67. If he takes his benefit at 62, what he gets is 70% of the benefit that he would have gotten at age 67 in terms of his monthly check. If he takes the benefit at 70, he gets 124% of the benefit that he would have gotten at age 62. So the question, and this is a really common question that seniors have, is, so when should I start taking my Social Security benefit? And that's why I'm actually doing a separate Pearl of Wisdom on this. But to give you kind of a simple way of thinking about this, once again, if Frank started taking his payments at 67, once again, we're assuming that right now he's 60, if he started taking his payments at 67, he'd be getting $2,000. Assume that if he was taking his payments at 67, he'd be getting $2,000 a year. If that were the case, but instead he started taking the payments at 62, he'd only be getting $1,400 a year, right? A lot less. If he waited until he was 70, he'd be getting $2,480 a year. he can't wait beyond 70. You have to start taking your Social Security payments by the time you're 70. But of course, the good news about waiting until 70 is your payment is much higher. But the bad news about waiting is that you haven't been paid any of the payments that you would have been paid starting either at 62 or at 67. So how do you figure this out? Well, the kind of the standard that I had always heard was, so the benefit that you derive from waiting either till you're 67 or until you're 70 only shows up if you've lived a lot longer, because then the extra payments that you get make up for all the payments that you didn't get earlier. Here's this is just a kind of an easy way of kind of thinking about this. For example, the numbers that I just gave you, if you took all of the payments, if you assumed that Frank were 80 and he died at 80, and you were saying to yourself, so if I die at 80, what will have been the best for me in terms of having started taking payments at 62, 67, or 70? Well, if you just add up all the payments at the different rates that we talked about, if Frank had started at 62, by the time he's 80, he would have gotten $302,400 in payments. If he started collecting at 67, then by the time he's 80, he would have gotten $312,000, only slightly more than the $302,400, and he wouldn't have had the ability to take the money that he originally got and invest it and reinvest it. Finally, if he started collecting at 70, then by the time he's 80, he's only actually gotten $267,840 in payments, actually lower than the other two. That, combined with the fact that he didn't have the chance to invest and reinvest the other money, means this did not turn out to be a great deal for him, right? The only other thing that, and I know that these numbers are very different if Frank were, say, to live to 90, because by that point, the effect of those extra payments or the extra high payments starts to outweigh the loss of the early payments. But remember, also, if Frank dies, Mary gets to take his payment. And assuming that Frank had the higher Social Security payment, when you're doing these kinds of calculations, the question really isn't, so what happens if I die at 80? It's what happens if I or Mary die at 80, or if I or Mary die at 90. So that's just a kind of a way of thinking about all of this stuff. You want to talk to your financial advisor more about that. Finally, when do you start taking your Medicare? Now, if you're still working, then you don't have to start taking it at 65, right? If you're not working, then you do. If you're still working, you have to start taking your Medicare within, I believe, 9 months of the day that you stop working. If you are working, then what you always can start taking Medicare, but you don't have to. And so if you want to figure out which one is going to be better, you need to figure out, if you're working, what's your insurance costing you? In many cases, if you're working, your employer is paying for most of your insurance cost, right? So, and if you're working and your spouse is still alive, you're probably on a family plan, so that family plan is covering the both of you. If, on the other hand, you start taking your Medicare, then both you and Mary are going to start, and you're Frank, both you and Mary are going to have to start taking Medicare. And then you need to be going through the standard Medicare analysis, the analysis that we're also going to do in a later episode of this series. First, you want to figure out what your Part B deductible is going to be if you're on Medicare. If you're working and you have a substantial salary, that Part B deductible can be very, very big. Then what's going to be the cost of the supplemental insurance? Because Medicare Part A and B don't cover everything. That's the reason why most people buy what used to, everybody would buy MedX. Now there are a number of supplemental insurance policies, but that's why everybody buys the supplemental insurance to cover those gaps. Third, what's the cost of your Part D plan? Because there isn't the old Medicare doesn't automatically cover drugs. That's your Part D plan. You want to figure out what that's going to cost you, especially if you've got any kind of serious amount, if you've got an illness, or serious drugs that you're taking. Finally, you want to take all three of those, compare them to what a Medicare Part C plan would cost, the so-called private Medicare plans, often called Medicare Advantage. And then you want to compare all that to what you're now getting with your employer. That's kind of the way that you would think about that analysis. For more, though, you would probably want to talk to a specialist who deals in these issues. Finally, two small things. You get to this age, you may want to consider changing your powers of attorney. First of all, you're probably, if you're Frank and Mary, you're naming each other as your agent. And maybe, and this happens a lot when people come in and they've got another relative as the alternate, because they did their powers of attorney when their kids were 15. At this point, you may be able to name your kids as the alternates. You may actually want to name them as your primary agents, but that's up to you. And remember that if you've got a trust and a lot of your assets are in trust, remember that even that if you've named someone as your agent, that's not going to give them the ability to handle the assets that are in the trust unless the trust specifically refers to the power of attorney and says that they can do that. Take a look at your healthcare proxy. That's the other important document that you may have done a long time ago. As I mentioned in my first presentation, the two documents that you really have to have as a person under 60 are a power of attorney and healthcare proxy. At this point, you may want to name one of the kids as the alternates. You can only name one person at a time. You can't name anybody jointly and severally on your healthcare proxy, but you want to be going back and look at it. Once again, the goal of all of this, the goal of all planning for seniors, fame and fortune has passed you by. You just want to get a good night's sleep. So the question is, if you're not troubled by these things and you're in your 60s, that's okay. If you are concerned about them, though, talk to professionals and see how to help yourself sleep better at night. Thank you very much. I hope you enjoyed the presentation, and I hope you enjoy the other presentations in this series.